At Five Star Bank, community is at the heart of what we do. Every day we strive to have thoughtful solutions for our customers and help our communities prosper. Honest dialogue about the issues affecting the region is vitally important to that prosperity. We are proud to be part of the conversation and hope you'll join in.
A strong and impartial judiciary is considered to be one of the key protectors of our liberty in America. The role of judges, those ultimate arbiters of justice, and those of juries, 12 peers drawn from our community, are considered essential in ensuring that our constitutional rights are respected and that our government lives within its lawful boundaries. What is the state of our judge and jury system today? Answering that and more are retired Judge Brian Van Camp and McGeorge School of Law professor Joseph Taylor. Judge Van Camp, what is the importance of the judge and jury system today?
I think you said it best, Scott. It is the defender of our individual liberties and our protector against an autocratic, overweening, dictatorial government.
And Professor Taylor, what's unique about our system as compared to all of the other systems of jurisprudence in the world?
Well, I think that we've already touched on that. I think the jury system is certainly a novelty among the world's nations. And I think it is key to the freedom and the rights that all citizens have. And if you look back over history, you can see that. And you can see what's happening in the world today where those countries don't have that.
You say it's a novelty. One of the things that we hear on an infrequent basis is cynics who say, what's so special about 12 people, and why would you give 12 ordinary people the awesome responsibility of deciding weighty matters like complex litigation or even life and death?
Well, my answer to that would be, after trying well over 100 jury trials, is that I think that jurors live up to that expectation.
Without any special training?
Absolutely. They come in there with their own life's experiences, their common sense, and they understand and generally will follow the law given to them by a judge, and they'll apply that. And I have not seen that fail in all the jury trials that I've tried.
But Judge Van Camp, don't you ever get disappointed? Haven't you ever been disappointed by juries? And like, my God, these people, they just don't get it.
Not yet. No, in trying some, as a judge, 300 jury trials, I have never seen one that I thought they got it totally off base. The judge is empowered to sit as a 13th juror, and overrule, override. I may quibble with certain amounts or maybe certain findings on 1 out of 6 or 8 counts in a trial, but I'll agree with Joe. I think they rise to the occasion. Some studies have shown that the more people making the decision, the better the decision.
Really?
And,
now that's interesting, because isn't there a little...
I'd go for 12 citizens with their own rich backgrounds and experiences against any judge.
Isn't there though a push because of cost constraints and things like that, where they're saying, well, 6 is good enough, or, you know, what's the magic number with 12?
Yes, in federal courts you can have 6 or 8 people. In a number of states you can have fewer than that. Frankly, in England, you don't get a jury for either misdemeanors or even less than serious felonies. So the United Kingdom, where the birthright of every Englishman, by God, is a right to a jury trial, isn't so much anymore. I think it's costs and time. They just can't afford it anymore.
Professor Taylor, you've been a public defender.
I've been both.
And you've been, I know, prosecutor and public defender.
That's true.
But putting on your public defender hat for a minute,
okay.
How important is a jury to ensuring that the accused gets a fair shake in court?
Well, I will go back to the answer I gave you before, and that is that I think juries get it right. And if you have a situation where you believe that your client is overcharged, or you believe the client is not guilty and you have that burden of proof, I think a jury has been very reliable. And in all the cases that I tried, both as a defense attorney and a prosecutor, I didn't walk away from any experience feeling that it didn't work.
It's interesting that you both are such supporters. I was reading a recent article quoting our Chief Justice, Tani Sakayui, and she was making the remark that she felt that our court system, our trial and jury system, is really under siege in this state. And she went back to the old Gideon versus Wainwright example.
Sure.
And she said that today, there's a good chance, increasingly, that you can't get a fair day in court. What's the truth of that?
Let me just say that it depends on whether you're talking about civil litigation or criminal litigation. My experience is that a criminal defendant can get a day in court within the system because there are certain statutory and constitutional guidelines that require that. The problem is that the bench is only big enough to handle so many cases. And generally that works to the disadvantage of civil litigants.
Is that true, though, about getting their day in court, even if they're in a criminal trial? Because there are also many observers who state that justice is weighted and freighted with the vagaries of economic advantage, meaning that, in the O.J. Simpson case, for example, one of the ways that case turned things on its head is that for eons, one of the paradigms that many have said is that if you are a minority in America prosecuted for a capital crime, especially when the victim was Caucasian, that in fact that it was essentially more likely than not that you were going to lose. Well, O.J. with his dream team really sort of really outdid what were the expectations of how that was going to end up. And so some came to the conclusion, Professor Taylor, that in fact that class now even trumps race. If you got enough money, you can get the justice that you can afford to buy.
Well, now that's something I won't argue about because I happen to believe that lawyers make a difference in a case. And I've seen that in cases that I've handled. I've watched cases like that. And we know that when we teach our students how to try jury trials. Some attorneys are more effective than others. And I think if you want to go back to the O.J. Simpson case, there were several things that happened in that jury trial that, as far as I'm concerned, indicated that Johnny Cochran was a superior attorney. In fact, the judge even chastised the prosecutor at the front end of that jury trial for what was considered to be improper conduct, and that was not a good start to that trial.
Well, but Scott, I'd like to go back to the Gideon case. That was a case where the U.S. Supreme Court said if the accused cannot afford a lawyer, then the state will hire him. And that was one of a number of cases that came through the Warren Court, largely in the late 50s and 60s, that started with, or included the Miranda warning, where it said, especially in some of the southeastern states, you can't bludgeon your accused into a confession. You're not going to do that. You have a right to a lawyer. If you can't afford one, we'll give them to you. You have a right to have a jury of your peers, and picking off the people of your race or gender or religion isn't going to work. There are a whole series of those cases. So does money make a difference? Or is some lawyers out doing the others? That's true. But I think we've seen a steady progression for 50 years that try to bring that balance, especially when you compare it to those countries where there's no right to a jury. I was in China a year or so ago and had an interest. I served as chair of our jury committee for 15 years and had an interest in that. So through Dan Lundgren's office and the State Department, I sat down in the embassy in Beijing with a law professor from China who's trying to bring the American jury system to China. He says in their system, judges are corrupt. First, they sell their votes to the bosses, as they call them, the corporate. But secondly, they have to send their decision over to the party offices before it becomes final.
Really?
He says they're not independent and they don't make the final rule. And they don't have juries, so there's nobody watching the judge. It's, as I told the presiding judge in Shanghai later that same week, I said, you know, you decide the facts and the law. I said, I only have to decide the facts. I hope you're making twice what I'm making. But the point, Scott, was if you can decide both the facts and the law, you're going to decide that case. If I decide that you really were someplace that night when something happened, and then I apply the law that if you did that, then you're going to prison. I'm sorry. So it is a critical check in our system, and I think we lead the pack. So, of all the jury trials in the world, some 95% are held in our country.
Really?
So that means the judges are on their own, and in too many cases, Russia, China, Venezuela, around the world, South Africa, well, not South Africa, but in those, the judges work for the Ministry of Justice. Well, wait a minute, the head of that ministry is sitting there with the Ministry of Education, Minister of Roads, Minister of Finance, Taxation. When the guy in the corner office goes, you go. So you've got a vested interest in keeping him there.
In perpetuating.
Well,
let's come back. I have to tell you, Professor Taylor, that there is, I've never been selected for a jury. I always get thrown off before, but when you talk with your coworkers at a job or something like that, jury duty, Judge Van Camp is describing this as a very awesome check and balance to our system and a great responsibility. But anecdotally, people tend to look at jury duties, oh my gosh. What do you think is the state of the public's understanding and participation in the jury system?
Thanks to Judge Van Camp, I think he informed me about the statistics in LA County. And in LA County, if I understand it correctly, it's about 20% of the people that are directed to show up for jury duty, in fact, show up. What we're talking about is 4/5 of people don't do it. And sure, it can be an inconvenience. In my experience in Sacramento, I don't think it's anything like that in Sacramento County. And I think that the participation of jurors has descended over the years, and I think part of that is that students in school don't get the civics education about the system and about the duty and how important it is and how it's tied to their freedom and all that. So I think that may be part of it. So I think the situation in California is such that we need to do more in our educational system to show how important that is. I really do believe that that would elevate the levels of people that show up for jury duty.
I'd agree with Joe, but I think it's part of a trend of less and less involvement with our overall government. I mean, how many of us vote? What's that, 60, 70% on a good day?
Right.
In 1830, Alexis de Tocqueville wrote in his Democracy in America, he wrote of the volunteer spirit of the young Americans in all manner of ways. There are voluntary associations. When it came to juries, he says they participate fully. They take that as a means of participating in their government. And they reveled in it. It gave them a magisterial sense, and they would not be there for anything. I think that's missing, and whether it's what Joe says, our schools we don't inculcate it enough, there are other values crowding those out, we just don't have that enthusiasm to help run our government.
When de Tocqueville took that tour as a young man, and he did marvel at all those things,
right.
If he was coming back in 2014, what do you think he would say?
He'd say, where did they go? Where did that young nation go? Those people were proud of the nation that they built. There was a flag in every home and every school. They were proud, and we just don't see that same pride and level of involvement.
Do we not?
By the way, I don't disagree with anything he said there.
Go ahead.
Well, I was just going to say that if on the 4th of July, and I'm out riding my bike, I don't see too many flags out there anymore. I mean, that is disheartening to me. I can't imagine that.
John Adams wrote his wife saying, let the 4th of July, I think in the original, he said, let it be the banner day, let there be parades and fireworks and horns and barking dogs and everything. He went on and on about that. We don't do it that way anymore.
This is interesting that you both are connecting the support for our system of justice directly to patriotism and sort of core beliefs in the country. I don't think that I've heard it articulated quite like that before. Can you share a little bit more on that?
Well, without getting into maybe topics that don't relate to courts and juries, I'm sure I could expand on it. I have some views about that. But as it relates to the justice system, I come back to the point I made. I think people are not invested in it. They don't translate that to their personal responsibility. But I do think that the situation is curable, and I think it is.
Well, what might be some of those cures?
Well, I go back to parents and teachers explaining this in some detail, giving them the mock experience. You know, when we have high school students that take part in the mock trial program, it's a statewide program and they have them across the nation. Those people I don't think have any problem. I think they are invested in it, they've devoted their own energies to it, and they see this as their own system of justice. Not enough people get that experience.
All right, I'm not going to disagree with you, but I do want to say this, that going after the kids and their parents in some ways seems like low-hanging fruit. When I go back to the same article that Chief Justice Kantil Sakayui wrote, and one of the things that she was complaining about was the lack of civic support by our elected officials, those people who embody our form of government as elected, on delivering the basic amount of funding necessary, in her opinion, to ensure that everybody gets their day in court. So, I mean, you can go after the kids and their parents, but let's attack the rich and the powerful for a second. What's their responsibility?
Well, you're going back to what the Chief Justice is fighting right now. And she has talked about the underfunding, serious underfunding of our system of justice. And that is true. And so the politicians certainly should understand and say that's one of the primary obligations that government has.
Our courts, Scott, have lost $500 million in funding in the last 4 years, which means we have closed courtrooms. Los Angeles closed 16 courthouses. This translates to court delays. Courts are only open 3 or 4 days a week. You can't get your matter heard for months. If you're looking for child support, if you're looking for some resolution, if you're looking to enforce contracts, if you're trying to vindicate a right or wrong, you just can't get to court anymore. The court delays mean justice denied. So she's dead right. We have to support the courts with our funding. There are other reasons why people can't get to court, though, and that is it's just so expensive to get to try your case in court. I heard the other day, to go through an uncontested divorce, it costs the average person half a year's earnings.
Half a year's earnings?
Half a year's earnings just to get an uncontested. Well, I mean, this is very pricey justice. And that goes back to your Gideon case. That was a criminal case, but Chief Justice Tani Kantil Sakayui and her predecessor, Ron George, have been trying to get a civil Gideon program together. So we fund civil attorneys for the necessities of life, the things like child support, evictions, rights to different support payments that get clogged or lost because of lack of funding. There's a number of ways that we could step up as a society to improve the access to justice that we're talking about.
Well, putting on my civil justice reform hat, though, do we want more people in court? I mean, you know, one of the favorite whipping boys of jokes is always about lawyers. No offense, gentlemen. And
Gee,
how,
I've never heard that.
Is that right? Yeah. Oh my, good to mind.
Glad you came here today, huh? and so, on the one hand, one man's justice is another man's sort of unnecessary litigation. How do we strike that balance?
Let me suggest that people like Judge Van Camp, who are now doing something different than operating under the structure we've known for so long, there are sources where I think domestic disputes and other civil actions can be resolved short of going in, selecting 12 people and a win-lose situation and that sort of thing. And I think the system is evolving that way. I think the system is quite different today than it was 30 years ago. And you see a lot of ADR stuff, the kind of stuff that can resolve disputes of this kind in a way without the mega costs to government. And I think you're going to see more of that in the future.
Let's talk about some of the things that add to those mega costs related to juries. So we talk about the lack of participation in the jury system in LA County and the fact that it seems many people think of it as more of a burden than a privilege. On the other hand, if we watch these cop procedurals on television or, court-related TV and things like that, we hear about all of these hired guns, jury consultants, behavioralists, people that are doing scientific algorithms on the perfect composition of juries and all of that. Is that fair game, or is it fair that maybe the lay public starts to feel that what's my participation matter because the system is gamed anyway?
I think most of those cases are in the time when those jury consultants are used, often by both sides in my courtrooms. I've seen the jury consultants sitting back of both benches. You've got a great deal of money at stake. It's Exxon versus Microsoft. These are weighty matters, and I don't fault them. I don't think that's inappropriate to get the best analysis of the people. They're going to make the decision. What can we know about both them and about the psychological science of what's the best approach? Doing mock trials in private settings. I don't think that speaks to the problem. What we're talking about we're really at the lower end and trying to get access, trying to get the people into the labyrinth of the court system with some clue about what's going to happen. I wouldn't curtail that. On the subject of diminishing number of jury trials, there are a number of reasons. Joe mentioned one. One is the alternative dispute activities in both arbitration and mediation, trying to get together to resolve it probably won't be a home run ball, but at least you get the thing over and you're on with your life. Any number of cases that used to come to court are not are barred by contract, because in so many contracts you waive your right to a jury trial. So when you sign up for a credit card or a phone or buy a refrigerator or hire a stockbroker, all those agreements say we'll arbitrate this. Now there's a move in Congress. The trial bar is trying to make those illegal. They've been honored since 1926 in the federal level as being a better, more expedient way to deliver justice. I think the jury's out, but I think there's some balancing that's going to come in. But as Joe says, you can certainly get the case resolved for less than 3, 4, 5 years, and the kind of money we're talking about.
Also, I think that there's a movement to restructure the legal system and an expansion of paralegal services and services of that kind.
Right.
And we see that in California today. In fact, there's a task force in the California State Bar that has looked at the need for lawyers, first of all, to know the day they get their ticket to practice law, how to handle these cases. They want law schools to give people that practical advice, and law schools are now starting paralegal programs to have a buffer in the middle to talk about cases like what Judge Van Camp talked about. If two paralegals representing parties in a civil dispute, and particularly domestic relations, and they're skilled and experienced in that, they can resolve it at a much lower level.
In our final moments, gentlemen, if you could pick just one thing that could be done to move the needle to enhance participation by our citizens in the jury system and the legal system, what would it be? In our final moments, one thing.
Well, I can tell you that at least in a very small way, McGeorge has done that by setting up a mock trial program where we invite citizens from this community to come in and serve as jurors. And once they have done that, they're hooked. They love it.
Okay. Judge Van Camp, the final word.
I think funding, Scott. I just think we have to support the courts to keep the doors open, to keep the process moving. We can't have jurors sitting out in the hallway for hours or days trying to just get the matter solved.
And we will leave it there.
Thank you.
Thank you both, gentlemen. And that's our show. Thanks to our guests and thanks to you for watching Studio Sacramento. I'm Scott Syfax. See you next time right here on KVIE.
At Five Star Bank, community is at the heart of what we do. Every day we strive to have thoughtful solutions for our customers and help our communities prosper. Honest dialogue about the issues affecting the region is vitally important to that prosperity. We are proud to be part of the conversation and hope you'll join in.
All episodes of Studio Sacramento, along with other KVIE programs, are available to watch online at kvie.org/video.